Good morning, Brendan Begley here with McIntyre Elder Law. This is Latte, lawyer, and today I want to talk about divorce. If you get divorced, should you change your will? And the answer is the answer I always give. It depends. So your will specifies your family composition. Probably at the beginning of the will says I have these heirs, I'm married to this person, that sort of thing. It does that for a reason because those individuals are entitled to things under the will or maybe entitled to things beyond the will. A spouse is entitled to a certain amount of assets despite what it says in the will, okay? Unless there's a premarital agreement in place or a postmarital agreement in place, and let's just assume that there's not, because most people don't do that. Maybe they should. That's for another video. So, assuming there's no post or premarital agreement in place, the will and statutory law both control what happens with respect to the spouse, okay? So the spouse is entitled to either what's under the will, or if that does not equal, if it's less than their statutory share, they can get their statutory share. So if you are still married to your spouse, okay, when they die, and they don't leave you in their will or other testamentary agreement like a trust, something like that, your share that you're allowed to have under statute, you can elect to get that share. But what happens if you divorce? Do you have to change your will? Usually, no, you actually do not. Because that portion of the will that divides to the spouse is revoked by operation of law through the divorce, right? So once you're divorced, once that divorce decree is signed by the judge, you then can just basically strike out that provision in the will that leaves anything to the spouse. But it helps to make things clear, okay? So clarification is a big deal. I've seen where a spouse has maybe gotten divorced in another state, okay? And it's not on record necessarily in North Carolina. They file the will once the spouse has died in North Carolina, and they act like the spouse, and even though they've gotten divorced and tried to receive their share or do receive their share, which is a very dangerous thing, okay? So you might want to just go ahead and update the will to prevent anything like that happening, because it's a possibility. So revocation of the provision, okay, that leaves something to a spouse happens by operation of law immediately upon divorce, but you should probably still change the will. If you have any other questions about estate planning, will drafting, divorce, whatever, give me a call, 704-259-7040.